Okay, I'll quickly introduce our respected speakers. I'll start with moderator CA Tejas Parekh. So, CA Tejas Parekh is practicing with Ms. Parekh, Pankaj Parekh, which is a 35-year-old firm. Prior to practice, he's worked with EY as an article assistant. He's conducted various training sessions on real estate sector, e-way bill, e-invoicing under GST during his professional tenure. He's provided advisory, representational, and compliance assistance in the field of GST and income tax across various industries. He's also written different professional magazines on direct tax and indirect tax topics. He's also co-opted member of various committees of WIRC and GST and Indirect Tax Committee of ICAI. So, CA Tejas ji, I would like to welcome you. Thank you for being here. As panelists, we have our first panelist, CA Karthik Iyer. So, CA Karthik Iyer is a proprietor in his firm KS Iyer and Associates. So, just to add on, I've been following your firm and your work while I was looking for articleship. So thank you for being here. Also, his qualifications are that he's a fellow member of ICI. He's also a holder of Information Systems Auditor. And apart from that, he has his independent practice since 2003. He has been actively practicing under RERA since 2018 with a specialization in complaint filing and representation. Also, he's involved into various processes such as delay in possession, fraudulent sales, structural defects, and regulatory non-compliances. He's also a co-author to the book Maharashtra RERA and Law Practices published by ICAI. Additionally, he expertises in FEMA, direct tax advisory, representation before government authorities, international assignments in UK, Europe, Gulf, and Southeast Asia. He's also known for his jurisprudence analysis, logical reasoning, and structured decision making. Thank you, CA Karthik Iyer, for being a part. Our next panelist, we have CA Aditya Zantye. Just to introduce him briefly, he's done his qualification of DISA, Diploma in Information System Audit, along with BCom. He's a CA in practice for last 9+ years. He's also a current partner in Accord & Co. Chartered Accountant firm. He specializes in the area of RERA advisory and compliance, bank audit, stock audit, tax audit, and GST for real estate sector, along with project accounting and assurance services, outsource accounting, and corporate law services. There is a huge list which goes on, and I would just like to summarize that his interests are into information technology, various parts of implementation into information technology. He's also handled litigation matter before VAT authorities, RERA authorities, and he's raised concern of chartered accountants issuing Form 5 during pandemic through representation to RERA. He was also a faculty of Advanced ITT of Thane branch. He's been associated since a long time with ICI. So thank you, C. Aditya, for being here. I would like to invite Mr. Sumit Kapoor from our previous session to give a memento to all our speakers. C. Tejas. Over to you.
So good afternoon, everyone. So basically this panel discussion, we have jotted few questions for I have panelists, and they will give their expert opinion on that. Predominantly, majority of the questions they belong to the precedents of various tribunal judgments or high court judgments or maybe Supreme Court judgments. So, and at the outset, I would like to thank WRC and CM Angesh Ghanikar, the RCM, to give me this opportunity and speak before this esteemed audience. So we'll start, Karthik sir and Aditya. So my first question is to Karthik sir. Karthik sir, the contract means whenever we go and buy any property, so there is an agreement which we sign with the developer. As a buyer, we sign agreement, and in that agreement there are n number of clauses. And normally everyone has their experience that these developers they don't amend any clause कि नहीं ये हमारे advocate ने बोला है, so हम ये नहीं change कर सकते, ये ऐसा ही रहेगा. So whether as a home buyer tomorrow if there is any dispute between me and the developer, so tomorrow can I go to the court of law and say that the points or the clauses which have been mentioned, these are all one side questions and I need a relief or something like that if tomorrow some dispute happens? So I would like your expert opinion on this.
Yes. Now we'll have to see this in context of pre-RERA and post-RERA contracts. There are lots of projects which have commenced before enactment of RERA, that is before 2017. And still, most of the cases are pertaining to pre-RERA contracts. When I say pre-RERA, it pertains to the period of MOFA. The MOFA Act itself had lacunae, one. Second, there was no proper enforcement mechanism for MOFA. So, the allottees, in case of pre-RERA contracts under MOFA regime, they had very limited option. They had only two options, whether to, one, they can approach the National Consumer Forum or the courts. The courts, as you know, take pretty long time. Even National Consumer Forum also takes pretty long time for disposal. And when we, from the allottee's perspective, as a home buyer, go to the developer for booking a flat, there is literally no option for us than to sign on the dotted lines. Everything is standardized. Even a simple comma or full stop is not changed in the agreement for sale. The standard reason given is, no, it is as per the legal, it's a standardized document as per the legal, the solicitors and they are vetted and we cannot change. So we are dealing with the front office. There is no, and the allottees also, they go without seeking the legal help, legal assistance. In such circumstances, when a dispute arises, the default, delay in possession. When the delay happens, the default happens, when the developer defaults from the agreed date of possession, he is unable to give, a lot of consequences arises. One is the EMI, the allottee has to face the EMI burden, the rentals, so many things. He is mentally in a strain. Here, the Supreme Court of India in Venkatraman Krishnamurthy versus Lodha Crown. This is a good case. It's a story. Mr. Venkatraman, he booked a flat for 7.5 crores. He paid 2.5 crores. In his agreement, it was mentioned that he will get a possession by June 16 with a grace period of 1 year. And it was also mentioned that in case if possession is not given, handed over by that time, the developer will pay 12% rate of interest. The allotee approached the National Consumer Forum. And his enthusiasm also, he asked for refund along with 18% per annum interest on a compounded basis. Okay. The Consumer Forum gave an order. What order? He asked for refund. The Consumer Forum ordered that no, everything OC is received and everything you give, you take possession. You don't take refund, you take possession. Then it gave interest at the rate of 6% per annum from the date of default. All these things the NCDRC did. The aggrieved allotee was not satisfied. The immediate appeal is for the Supreme Court. He approached the Supreme Court. The Supreme Court analyzed. In light of RERA, it analyzed, because this is pertaining, although the contract was pre-RERA, the complaint and the case is happening in a post-RERA. It analyzed the preamble of RERA. What does the preamble of RERA say? It is enacted for protection of interest of home buyers. It is for regulating the real estate industry. RERA casts onerous responsibility and obligation on the shoulders of the developer, which he has to fulfill. So many things. Then it pitted for sale, which is governed under Indian Contract Act, against the provisions of RERA. It distinguished the provisions, the terms and conditions of the agreement for sale, into which are oppressive in nature, which are unconscionable in nature, and which are opposed to public policy. Which are the provisions which are opposed to the public policy? Anything which exploits the allottees, which is vague in nature, which doesn't bind the developer. It struck down on all those terms and conditions. It heavily came down on the order of the NCDRC, stating that it had no right to change the terms and conditions of a contract between two parties, which is entered into pre-RERA period, and it had to enforce the terms and conditions. So it awarded refund. You cannot force the allotee. The default has happened. The allotee has got two choices, whether he can continue or he can withdraw. If he wishes, if he has chosen to withdraw, the authority, the Consumer Forum, or whichever court has to accept it. So it accepted, it reinforced the right of the allotee to withdraw. It gave refund at the rate of 12%. per annum, and it struck down the order of the NCDRC categorically, stating that it had no business interfering, and it overruled the terms and conditions of the contracts, which was opposed to public policy, which was one-sided contracts. So what it says is the contract has to be balanced. It has to take care of both the sides. It cannot be unilateral. It cannot be exploitative in nature, especially one thing we'll have to see, the developer is at a higher level. The allottee is at a lower level. The developer is burdened with onerous obligations and responsibilities under RERA. Why? Because he is collecting money from the public at large. The RERA itself was created to create level playing field between the developer and the allottee. As such, any of the terms and conditions which are oppressive, which are in violation of RERA will be struck down, and which are beneficial or on the promises on which the developer has taken money from the public will be upheld. 12% rate is more than the rate which is prescribed under Rule 19. It is not SBAI MCLR plus 2%, which is coming even now also it is 11% only. So it upheld. When you agree to pay, you pay. At the same time, it will be interesting if the converse can be true. If the same 12% and the allottee also has to pay 12%, need not be true, because the allottee is a public at large. They cannot circumvent the provisions of RERA. So this is the interpretation. This is a nice judgment which is given by the Supreme Court. It has analyzed the Indian Contract Act with respect to RERA. And it's nice. It has quoted so many case laws also. And it has held that once the developer defaults, under Kusheshwar Prasad versus State of Bihar, another Supreme Court decision, the person who is doing wrong cannot benefit out of his own wrongdoing. That is one of the major principles. Once he is defaulted, consequences will follow. And the developer, most of the time, what he tries to wriggle out of the liabilities which follows. So that may be reduced, but it cannot absolve him, and he cannot claim relief out of that. That is the main contention.
Thank you, sir. So now I'll come to Aditya for the next question. So Aditya, typically in all the documents or all the agreement for sale or a conveyance deed, so there is always an arbitration clause in that. So whenever I am signing a document, I am agreeing that tomorrow if there is a dispute, so I have an option of arbitration. So tomorrow, can I go to RERA authorities? Can I go to the court of law? Even as I have signed the document with you stating that I will be only doing arbitration. So my all other doors are closed if there is an arbitration clause.
Now here, if you will see the model agreement of RERA released by RERA, so in case of there is one clause in the dispute, that is dispute resolution. In that case, it has been clearly written that any disputes arise under this agreement will be covered under the RERA Act, and the appropriate authority is the RERA authority, that is RERA authority. Now, your developers often have an habit to, it is obviously if they want to use a beneficial provision for their resort, like LOTs have certain provisions. So they purposely used to put this clause of arbitration instead of the RERA. And all the agreement, this especially is a case in case of all the agreements which were entered prior to 1st May 2017 before RERA came into inception. So there was a specific clause of arbitration, and MAHARERA at some point of time, they gave a judgment that arbitration, if there is an arbitration clause, yes, it will not be covered under RERA's jurisdiction, and you have to resort to arbitration, compulsory arbitration. But we have New Tech Promoters judgment, we have Wintergreen case, and so now it is a set precedent that even though such clause, if you will see now at the time of registration itself, MAHARERA is not allowing this clause, arbitration clause in the agreement. So that point is solved there itself. And for other, the agreements which were entered prior, so it is in the New Tech Promoter judgment also, it has been clarified that it is up to the allottees where they want to resort, whether they want to go to arbitration, they want to go to tribunal, they want to go to civil courts. So it is completely dependent on the allottees, and promoter cannot take the benefit of this case and he can prolong the case judgment for themselves, and the allottees will go haywire here and there to different forums. That is the reason completely now it is a set precedent. All are giving the same similar judgments that now arbitration won't suffice. You have to compulsory take the resort to the MAHARERA. But second thing here, one more question plays is pertaining to section 79A, that is the bar on the jurisdiction of the other courts, when especially when MAHARERA enjoys a jurisdiction of certain particular sections, there's section 11, section 13. So these section, we have contradictory judgments there also. Now in recent case, Sahyog Homes Limited, we have seen that there was a question of allotment letter in an agreement where it was in 2018-19 itself, the agreement and everything was decided, but there was a delay in signing the agreement, registering the agreement. And by the time MAHARERA, the RERA came into inception from 1st May. So here, then the developer obviously, he took the jurisdiction of the civil court. He said that, yes, the dispute won't fall under the jurisdiction of RERA authority, rather it will go to the civil court. But Bombay High Court gave a judgment that when there is a demand for a perpetual injection, first of all, if there is a perpetual injection being demanded, then definitely this case, because MAHARERA's jurisdiction start once the agreement of sale has been registered. It has been entered, because if you will see in 79A, all the sections to fall under the jurisdiction, there has to be an agreement for sale, there has to be a document. But here the question was to decide whether the clause pertaining to agreement for sale is expected or not, because here the question was to decide the per square meter rate itself. So that doesn't fall within the jurisdiction of MAHARERA authority or the tribunal. It will definitely fall under the jurisdiction of civil court. So again, this depends on case-to-case basis, where, because in another judgment, Yadavpalli Gopalan, there the court said that yes, you have to resort to MAHARERA. This dispute won't fall under civil courts. So this, because here it is clearly written that it is a specific injunction. When there is a specific performance pertaining to particular section of the act, then it falls under the jurisdiction of the MAHARERA. But that doesn't result that you cannot approach civil court and have other jurisdiction. So this will always be a challenge for deciding jurisdiction, but for arbitration purpose, it is pre-decided now that the MAHARERA will be the supreme authority for the purpose of this dispute resolution as per the agreements. So this clause itself is not allowed to be entered at the start of the inception.
Yeah, so we'll move to the next question to Karthik sir. Sir, in Mumbai, in and around and in the MMR region, where there is an open land, so there are the landowners who are the owner of that property. And typically now the developers also not purchase the land. They tend to enter into a joint development agreement with the landowners. So once, and it is a precedent that even the landowners have to be treated as a promoter in the RERA project and in the RERA registration. So tomorrow, if there is any dispute or if there is non-compliance by the developer or non-completion of the project by the developer, or tomorrow the allottees ask any compensation or something from the developers, and the developer is not in the position to honor that, or he has become insolvent or something like that. So whether the landowner, who is also treated as a promoter by RERA, be liable for such compensations to be given to the allottees or similar to that. So I would like your answer on this specific topic.
Now, why we have to restrict ourselves to landowners? There are joint development agreements entered into by the primary promoter with the investors also, with the project managers also, on a even contractors also, on a revenue sharing basis. The Bombay High Court has laid this contentious issue to rest once and for all. In case of Vadva Group Holdings, it's a recent 22nd February 2024 judgment, versus Vijay Choksi and SSSC Aesthetics. Here, this is one of the prominent projects in Andheri West, DN Nagar, called the Nest, Wing A, Wing B, SRA project, SRA rehab project. SSSC Aesthetics was a primary promoter who got the IOD, CC, everything. Then he fell short of funds. He roped in Vadva. They both entered into a joint development agreement. They had their share of ratio of sharing the saleable component of the FSI in the joint development agreement. Later, when the plan was approved and everything, they gave power of attorney to each other. They apportioned, allocated the flats which could be sold by SSSC, which could be sold by Vadva. And in all the agreements, SSSC Aesthetics was mentioned as the promoter, Vadva was mentioned as the co-promoter. SSSC sold their share, Vadva sold their share, they collected the money. SSSC Aesthetics is nowhere to be found now. ED has attached all the properties. It has abandoned the project and went. So what is the role of Vadva? Can it wash off its hands? Can you say, no, I am just an investor, came late in the show. I'm not liable for anything. No. It says, those flats are sold by SSSC Aesthetics. In what way I am concerned, I have not taken the money. I have not touched that money. So I am not liable for the flat allottees whose flats were sold and the considerations were collected by SSSC Aesthetics. The Bombay High Court laid this issue to rest. It says categorically, it's stated that under 2ZK, the promoter includes the landowners, the investors, and any and all other persons who have entered into revenue sharing agreement with the promoter. All of them are jointly and severally responsible for the project. They will share the liabilities as well. It was very categorically stated. With this Bombay High Court judgment, we can rope in the primary promoter, the co-promoter, the landowner, everybody, and make them liable for the consequences of default, including delay. Once a delay happens, the consequences are tremendous. So all will be equally liable, whether they have received the money or not, whether they have entered into the agreement with the allotee or not, they will be liable. So this Bombay High Court judgment is of very high relevance and importance, which lays down this contentious issue to rest. Thank you.
But sir, here I have one more issue over here. So in this case, the promoter or maybe a co-promoter, they were the entities, they were into this construction business here. But there are many projects where a landowner is a family members are there. They don't have any experience in the construction field. But by the virtue of this RERA Act, they have to be termed or they have to be treated as a promoter. They don't have any experience for the construction, for the selling or anything like that. So even in that case, the landowners who are the group of families or any individuals, they are not in this business, be held liable by the court.
The landowners, if they sell the land 100%, promoter develops the project, there will not be no question of any liability will arise. But if the landowner gets into a revenue sharing agreement, like, okay, it usually happens, the developer doesn't want to pitch in with that sort of money for acquisition of land. So usually they will rope in the landowner as a partner. Once the landowner is roped in as a partner, it doesn't matter whether he actually constructs or not, he is going to reap the benefits out of the project. So he will be allotted his share of flats, which he in turn will be selling to the public at large. Once he enters into this sort of arrangement and agreement, he will be held liable not only for his share of sale of flats, but for the entire project. So the landowner has to be aware and conscious of the fact of what all liabilities and responsibilities are cast on his shoulders post onset of RERA. If he thinks he can only, if anybody thinks rather, if they can only reap the benefits out of the project, collect money from the public at large, and be not responsible in any manner, they are living in a fallacy. They are living in their own utopia world, which they have to come out of. Ignorance of law is no excuse. With the onset of RERA, the noose has tightened around the real estate industry, especially the developers who used to have a free hand. They could come out with so many excuses, so many, this thing, it won't hold good. So anybody who is reaping the benefits, gonna collect the public money, money from sale consideration or money from the public, will be held liable and responsible under RERA.
Thank you, sir. So my next question to Aditya. So whenever there is a
redevelopment. I'll tell you one essence of the redevelopment agreement. In a redevelopment agreement, an irrevocable power of attorney is given to the developer. So, de facto, who is developing? The society. The society. They are developing. There are cases they have been held as a promoter. Yes, they are directly held as a promoter.
In case of, I think so, Vaidya Akash also,
Vaidya.
there is a judgment. So society was held as a promoter. And if you will see the definition of the promoter is very broad. Now there is one more second appeal means been pending with respect to SIDCO, whether SIDCO will be treated as a promoter under RERA. So that second appeal is pending in the High Court. So we will see that lot of entities will be considered as promoter now in short period of time, because the response, I believe that either you develop you construct yourself, or you are a cause of construction for that project. Because of you it is happening, then you have to be considered as a promoter. Now many promoters make a mistake. The investor concept I have seen particularly in registration, that there is an investor concept, and this investor concept is not recognized by RERA. Either he is a promoter or he is a LOT. So they come to me that how this transaction will be reported, that I have accepted money. So either it has to be a clear unsecured loan agreement with pertaining to interest. But you will see that investors, we have given a letter of allotment for their security or safety. And they say that he's my friend and all these arguments are given, because these friends later on file a complaint against these promoters, and they take the sort as a LOT. And investors are treated as allottees in many of the judgments, because it is clear if he is an investor, he is a promoter, treat him as a promoter on the portal of the RERA. You register him as a promoter, then we will accept it as an investor, that he has helped you for the construction of the project. But still, if later on he has bought many flats, 5 to 6 flats, and you are supposing him to be considered as a promoter, LOT, he will be considered as an allotee and not a promoter, even though he has bought a number of lands. Because the general ideology behind or misconception, I would say, is that if he has bought many flats and there is no agreement for sale, then he is a promoter. But RERA doesn't say. It has to be on paper and it has to be very well clear. So if you have given him letter of allotment, that means he will become an allotee. So similarly, society from day one, they are the promoters. Because RERA earlier came with a nomenclature as co-promoter. They tried to define it them as co-promoter. But later on a judgment came, High Court, how can you define something which is not there in the law itself? So now you will see that promoter itself is the common terminology used for all.
Area share gets easily translated into revenue. Area share. Yes. And I would like to add one more thing, the society. It also indirectly benefits because of the allotment. The developer, he doesn't shell out money from his own pocket. He collects the money from the public at large, pays the alternate accommodation rent, pays for the construction, everything. In fact, their old house is getting reconstructed through the public funds. So how can the society claim, no, I'm not responsible for anything, and go on, keep on changing the promoter if he defaults or anything? That's a fantastic aspect of RERA. RERA has given complete powers into the hands of the allottees. Both will be responsible. Any internal disputes will be governed under doctrine of indoor management, for which the public should not be allowed to suffer. Here, especially the Vadva judgment has even broached on this topic of doctrine of indoor management. Any dispute between two co-promoter, it will then they will create a dispute and delay. What happens to the public at large? Any agreement that has to be drawn in line and in consonance with the RERA Act. If the RERA Act, if under RERA Act definition 2ZK, the landowner qualifies as a promoter, he has to be classified as a promoter. They can share the duties and responsibilities. You are responsible for that. We are responsible for here. There is an internal agreement, internal arrangements between them. As far as the RERA Act is concerned, they will be considered as a co-promoter.
Even though their agreement speaks a different thing, their liabilities are different. So that they can take at a different forum and they can go on fighting for ages. But RERA doesn't bother about it. For them, for RERA, only allotee matters. So if the project is stuck, then both are responsible. Because if you will see, he's selling the landowner is selling his area share or he's taking a revenue out of that project. So that means he's earning out of that project income and pertaining to area share. He's giving commitment to that allotee. The agreement for sale is same. He enters at a particular date. So if any dispute happens between the promoter and the landowner, that is a different story altogether. But project should not get affected. That is the only concern. So when the project gets affected, the wheel will be lifted and both will be held. If the promoter is not able to complete, the landowner has to take the responsibility and complete it.
So we'll move to the next question. So Aditya, this is for you. So once I go to a RERA authority and a case has been considered and the complaint has been adjudicated. So now there are obviously the opposite party who is aggrieved, against whom the RERA authorities have given the judgment. So now if they want to file an appeal, so obviously there is a time limit for filing an appeal against the authority ka adjudication for the tribunal. And if there is any delay in filing of appeal, so in income tax, in GST, yes, there are cases on condonation application to be done. It is on the authority whether they will be accepting or not. But what is there in RERA? So whether it is time limit nikal gaya, to tum bhul jao abhi, ya is the tribunal, do they have the power to condone the delay? So can you please throw some light on this issue?
Yeah. First of all, the main purpose of this act is to settle the dispute in a lesser possible time. That is the reason in compliance of the section 32, they came up with the concept of conciliation. Now here, what is happening, developers are again going into that old mode of delaying taxes or getting the appeals delayed. They go file a contradict appeal into the civil courts or certain other forums, or even they go into appeal when there is at the prima facie itself there is no merits in the case. They purposely come after 60 days or 1 year or 40 days or what all sort of other arguments they are producing. See, now what differentiate between the tribunal and the civil court is that tribunal need not be so constrained in case of hearing the matters. It is not necessary to for them to follow the civil court procedure. Here they should consider on the basis of, there are two aspects. One is if someone is going in deterrence or abusing the law, then they has to hold themselves responsible for that purpose and they should not go or entertain this kind of appeal. But if there is a genuine case or there is a certain issue which the allottees or promoter might be facing, because we stay in a country where there are regulatory issues, there are delays, there are various kind of issues we are facing, and it's not easy to develop a particular project, especially when we start with a positive hope that the project will get completed, but during the project we face a lot of issues. So when certain aspects are there where the appeals should be considered based on whatever the genuinity reasons are there. You might have seen in income tax also that a delay condonation of more than 365 days has been condoned. But Maharera is tribunal is, as compared to, I have seen that it is very stringent. The perfect example he will give is in his recent case. Karthik, please.
Yeah. So there has been various precedents set by the Supreme Court that a pedantic approach should not be adopted by the court nor the tribunal. And when considerations are pitted against substantive relief versus technical considerations, the substantive aspect of the thing should be taken into consideration. So the tribunal has to weigh it on basis of natural justice, whether by allowing a particular case, the merit is upheld, or rather an injustice is done. In one of the cases, in my own case, a tribunal just threw away only 33 days of delay of filing the appeal. There were four appeals of the same project. Only one question of law was involved. It was a stalled project. The authority gave the relief for refund, but weirdly, the authority did not give the interest from the date of payments, but from an ad hoc date, which was 2019. That was a major injustice, and this was the only point of consideration. We had approached a tribunal. What happened? There was only 33 days of delay. Why the delay? One of the appellant himself died before in February. March, the order was passed and we had to file by May. So the legal heirs had to join. In another, that lady allottee's brain tumor relapsed. We had put up given the supportings of the MRI scan report also. Still, the tribunal dismissed the appeal, did not allow the delay condonation for a very simple reason that after 60 days, when the allottees had come, so we had a discussion. We told, okay, you can pursue the execution proceedings and appellate proceedings. They are mutually exclusive. No need to, there is no bar on exclusion or any of the things. Because that was pursued, execution proceedings is very short, online 2-minute procedure. And the process of appeal is quite exhaustive, long, and tedious. Without appreciating these facts, the tribunal dismissed the appeal, did not condone the delay for a simple reason that you are judicious enough to prefer execution, but you are not judicious enough to prefer appeal in time. Both were delayed. There were so many reasons. We had attached the death certificate, everything. No, dismissed. They made up their mind. So they have to see whether by allowing the appeal, what is the prejudice or harm caused to the allottee or to the developer. Is it benefiting the developer? Yes, of course. The developer, usually what happens, the developer, he delays the appeal because he wants to drag on the process. He doesn't want to deposit the money under section 43(5). So there are various reasons. If the developer delays the appeal, it should not be condoned because it becomes an abuse of process of law. But if an allottee, genuine allottee, if he delays, and that too with a little bit of delay, if the tribunal adopts such a strict approach, which which obstructs the justice, it is not, it is a condemnable approach. In fact, during 2018, Justice Kolhe had allowed, it was a landmark order, around 427 days of delay. So it depends upon basically judge to judge and bench to bench. So and in this case of agile real estate, this case of agile real estate, the developer had filed an appeal after 18 months of delay. And the reason was given that the company was undergoing internal restructuring. That was struck down by the delay was not condoned by the tribunal, and rightly so, because the justice, which you cannot delay the justice. Already the justice is delayed in the authority level. Previously, it was a pleasure in 2018. We used to get orders from Justice B.D. Kapadnis in 2 to 3 hearings in 3 to 4 months' time. But then after the onset of COVID, the entire process got delayed. And now it takes around a year and a half to get an order from the authority level. So already the justice is delayed. And the prime motto of RERA is justice delayed is justice denied. Make a swift justice, fast justice, provide relief, keep the wheel moving. There is a motto of the current chairperson. Keep the wheels of the real estate industry in rotation and movement. Oil the wheel well, good. So that is a motto, and the tribunal should supplement it and complement the justice deliverance process rather than obstruct it.
Basically, they work on a simple principle that if you are aggrieved by a particular order, then you will not wait for so much time to file an appeal. Because if it pains, if the judgment is in against a promoter and he thinks that something is wrong in this order, then he won't wait for so much time. There are n number of things that I have seen that he couldn't find a suitable advocate, or what sort of such kind of excuses are being given which are not acceptable, and that has to be dealt with case to case basis. So here I would say that in this particular sector especially, we have seen that there is enough time for an appeal. Even I have seen one judgment where the certified copy couldn't be obtained due to procedural delay, and the delay was not condoned because tribunal is expecting that you can submit the copy which you can download easily from the portal, and then you can give in writing that we will submit the certified copy in some time. So that is a possible way out in that case, and that cannot be a reason for condonation of delay. So your case to case basis, it will be dealt with, but tribunal will be more of, they should consider that what are the procedural delays, especially we face due to systems. Also, most of the things we have seen that extensions are delayed, or extensions, the portals get changed. So certain aspects needs to be considered by the tribunal, and they, on case to case basis, they have to deal with it, and they should not be more stringent like civil courts, because here if you will see the recovery amount, especially today, is more than 500 crores to be recovered. So the ultimate thing, yeah, the official figure on the portal, that 700, they are showing the positive scenario that 700 is the warrant issued and 200 crores have been recovered. So still there is no recovery, speed up is not there. Only we are getting judgments in favor, or even certain judgments are, I think so, if it is, if we cannot execute it properly, then it is just on plain paper. That's it. So your whole system should work in that manner. If they're expecting that everyone will file in a particular time, then yes, the recovery should also happen in time. That's what I expect.
And now the RERA has appointed 12 officers, especially
retired collectors,
for expediting the recovery process. And believe me, they are the recovery is happening. With the delay is due to the Tahsildar and the collector's end, which we also need to follow up constantly. We have to keep on communicating in writing. We have to put it on record that this is there. This order is passed on this date. On this date, it was submitted. On this date, it has so many days have flown, but you have not done anything. If we keep on communicating on a proper like monthly or fortnightly basis in writing to the Tahsildar and the collector, and we also cooperate in providing the list of assets of the defaulter developer, they also are inclined to take action. This has been my experience. But of course, the developer will do all that. We will adopt all the tricks under his sleeves to delay. But ultimately, once the long hold of law catches up in his neck, he will cough up and make the payment via settlement.
Yeah. So now next question is to Karthik sir. So Karthik sir, typically in the agreement for purchasing the residence, the project normally takes 3 years, 4 years, 5 years. And there are payment schedules to be made. 5% abhi dena hai. After that, 10% on plane, then X, then Y. So on and so forth. There are payment terms. But tomorrow, if there is a default by the developer and we wish to claim the interest for our payments, so how does that interest has to be calculated by the aggrieved party? And only the interest is the compensation for the aggrieved party, or any other compensation claim he can make. So for example, if I am not getting my house in 3 years, 4 years, as per the agreement on the date of possession, I am not getting it. So can I also ask for the rentals, because I will have to stay somewhere, I will be paying rent. So can I ask such another compensation also from the developer? Can you please throw some light on this?
Good question. Section 18 deals with refund. The heading of Section 18 is itself refund and compensation. Section 18(1) deals with case of a delay, the allottee, if there are two options given. If he wishes to withdraw from the project, when the developer is unable to hand over possession as agreed as per the terms and conditions of agreement for sale or any other document thereunder, that allottee will be entitled to refund with interest and compensation. The proviso to Section 18, it's an enabling proviso, which also provides for another option to the allottee, which is if the allottee wishes to continue in the project, he will also be entitled to interest. (18)(2) also speaks about compensation due to defects in title, land title. 18(3), the allottee, it speaks about the compensation for any other violations committed by the developer, or if any of the obligations cast by the RERA, if it is not followed, and if the allottee is affected, he can go for 18(3). The whole Section 18 is about compensation. Nilkamal judgment, the landmark judgment of December 2017 by Honorable Bombay High Court, categorizes interest itself as a compensation, one, and says that the interest is the basic amount which needs to be paid as a primary compensation to the allottee for opportunity loss. If this amount he had invested elsewhere, he would have got the interest, he would have reaped the benefits out of that. The interest word itself, why the word interest is used? It is a manner and a measure of quantification of the amount to be paid. It is not actually interest. It is not as if we are given a loan and we are taking this thing. It's a compensation. It itself bears the character of compensation. Second, when a default happens, there are various other consequences also. The person, there's a lot of mental strain. His whole plans is at a disarray. The developer, to avoid the liability, he doesn't respond. Everything goes on. It's like putting a stone into the well. All the communications doesn't get responded at all. There is a EMI outflow is there. He's paying interest to the banks. He's paying rentals. He would have been staying himself on a rented property with the plan to move in when he gets the possession. Because of the possession, he would have not accepted a job which is more lucrative or remunerative anywhere else. The schooling of the kids, everything is dependent upon the receipt of possession of the flat. So it gives rise to various compensations. The act is very clear. If you are aggrieved, you will be entitled to interest as a primary compensation. And if you are further aggrieved, you can plead and put up your case for additional compensation as well. And the New Tech judgment by the Supreme Court grants the interest as an unconditional and absolute right of an allottee. When it comes to the question of granting interest compensation by the authority, it has to be unconditional and absolute. No holds barred, no conditional order to be passed. As such, when an order of interest is passed, which is under section 18, rule 18 comes into play, which states that the interest will be, the rate of interest will be SBI MCLR, highest SBI MCLR, which is a 3-year rate plus 2%. The highest rate is 9.1% as on date, plus 2% will be 11.1%. Should be granted. How it is to be granted, how it is to be executed, it has to be paid on a monthly basis from the date of the order. Can it be deferred? No. But still, authorities pass the order of deferment till, okay, you can receive the money later. Whether such orders are valid? No. Coming to the case of COVID. So, we'll deal with the COVID later. So, this is absolute, unconditional grant of interest, no holds barred, and all the allottees should be treated at par. There is no distinction between a continuing allottee who does not wish to withdraw from the project and an allottee who wishes to withdraw from the project. In fact, an allottee who wishes to withdraw from the project How the interest is calculated is interesting. The interest for an allotee who wishes to withdraw from the project is calculated from the date of the first payment till the actual date of refund. This means that he is compensated right from day one of making the payment till the last day of receipt of refund. And complete restitution takes place in his case. And additionally also, he can claim for compensation for rental outflows, mental agony, harassment suffered, etc. If you have paid 10 installments in 10 different dates, the interest will be calculated from each of the dates till the date of refund. Yes, installment wise. So this is a concept of complete restitution, not from any arbitrary date or a default date. Okay, see, if you're paid, okay, 25% we'll calculate from that 25% or 50% or 75%, no. Right from day one of the booking amount to the part payment of the consideration, whether you have paid construction stage wise, etc. The interest is calculated from that date till the date of actual refund. Plus, you can claim compensation for all these things. Now, how the interest is calculated for a continuing allotee? For a continuing allotee, he is getting the flat. So he has to make the payments. For him, the interest will commence from the date of default, of date of possession. If the date of possession is 31st December 2017, then the interest will be calculated from 1st of January 2018 on the entire consideration which has been paid till 31st December 2017. And to what extent interest will be calculated till the date of actual handing over of possession. Actual handing over of possession. This is what the Act says, the rule says. This is what the authority has also held. This is how the interest is calculated, and continuing allotee also are eligible for compensation with the tribunal judgment of Malti Siroya case. Most of the authorities, when they pass the order, they say you are continuing allotee, you are eligible for interest, you have been granted, you are not eligible for compensation. It's a very basic, narrow, restricted interpretation which they take, which is not upheld in the tribunal. There is the RERA Act itself doesn't distinguish between continuing allotee and withdrawing allotee. It only distinguishes for the purposes of calculation of interest. If they say, no, you are continuing allotee, you are not eligible for compensation, it means you are not distinguishing, you are discriminating. That is not allowed under any act. Neither under Article 26 of the Constitution. You can discriminate. Once a default happens, there is only one class of allottees, that is aggrieved allottees. And they are entitled for both interest as well as compensation. In fact, the withdrawing allotee is at a higher footing. The continuing allotee is at a lower footing. He should be more entitled to the compensation. He is reposing faith on a developer who has already defaulted. So what is the basis of denying compensation to a continuing allotee? Doesn't make any sense. So that was confirmed in the Malti Siroya judgment. And I hope the High Courts and Supreme Courts also confirm the same thing. It has not gone to that stage. But definitely, one interesting case we have put up for continuing allotee. for rental compensation. It is the judgment is lying with the adjudicating officer. Hope it comes positive, then it will be a landmark judgment again. The implications are also huge. Yes. Again, the law of complete restitution applies. The principles of law of complete restitution, how is applied is you bring that particular allottee to the stage wherein he was before he booked the flat. So the entire amount has to be refunded, and this has been allowed by Justice B.D. Kapadnis, sir. He allowed refund of the sale consideration with interest, GST, service tax, VAT, stamp duty, and registration fees also. I'll finish. How he allowed also, and will tell you. The stamp duty he has allowed if the period of 5 years has lapsed. If within the period of 5 years, you can take refund of the stamp duty from the department itself by stating, showing the order that this is cancelled and we are entitled to refund. If that period of 5 years has lapsed, Justice B.D. Kapadnis has allowed the refund of stamp duty also. He has in his orders allowed refund of service tax, VAT, GST, etc. Now it goes upon case-to-case basis, bench to bench. When the developer pleads that no, we are not gonna get the refund of GST, so how can we allow to refund? That argument is sometimes accepted by the bench, but bench has to analyze it is whose fault that the allottee is in this circumstances. Why the situation has arisen? Is it due to the GST law? It is because of the default of the developer. He has to make the payment for that. He has to recompense. So the question is it's not whether the GST law allows the refund or not. The question is because of on whose fault the default such situation has arisen. If you had completed the project in time, no problem. If the allottee defaults for the payment, the allottee also will have to pay interest at the rate of SBI, highest SBI MCLR plus 2% to the developer. Yeah. Yeah, the allottee will get refund minus all the charges as per the terms and conditions of the agreement. The forfeiture will be, I think now it's restricted to 2% under the circular.
Allotment letter till allotment letter stage,
yes,
it is 2%.
2%.
After that, as per the liquidated damages in the agreement. As
per the agreement.
If you will see the model agreement, there is in clearly written that has to be agreed. No, the liquidated damages need not be specified at the time. So it is based on the case to case basis, whatever the agreement they have signed between, and if it is agreeable to both the parties, because it is a contract between both of them and it cannot be rewritten by RERA. So certain aspects will be decided later on, but that has to be reasonable again. Now we had a Supreme Court judgment that wherein 10% was even considered as a reasonable liquidated damage, but RERA doesn't allow more than 2% of forfeiture. So that again there is a debate, but that has to be between both of them, and that can be mentioned in the agreement that will be final. But multiple deviations cannot be filed with respect to agreement. Otherwise, it will go on changing and changing liquidated damages.
Deviations so far as, again, the initial Supreme Court case law comes. The deviations in so far as it is not opposed to the public policies may be considered, but if it is opposed to the public policy, exploiting the allotee will not be considered. Uploading has to be a standard agreement format which will be uploaded, which has to be in consonance with the model agreement also.
No deviation. What see the base of that agreement needs to be same. And in the entire act, nowhere they have given the percentage of forfeiture in the act. The percentage of forfeiture is given in the letter of allotment. And rest all, once your agreement is signed, and so after that, all the damages needs to be specified in the agreement. So that is not a pertaining to deviation. Deviation means if you are violating or changing the crux of the particular clause in the model agreement, then you have to give a deviation. So you are speaking the same clause in a different manner, that is a deviation.
For example, one of the developers in even post RERA, Mulund, he put a clause stating that in case of a delay, he will pay 25,000 rupee per month for a 1 BHK, 30,000, 40,000 rupee for a 2 BHK per month rental. And once the allotee accepts this compensation, he will not be entitled to approach RERA for Section 18 compensation. Well, now, whether this is valid, most of the allottees, they have accepted that. So would it preclude the allotee from approaching RERA for additional Section 18 compensation? What do you say? So it is void, it cannot be enforced. But then would you have to refund the rental received? Allotee shall have the right to approach RERA. So what happens? The developer has paid him rental also. Will the rental substitute the interest?
No.
Under Section 18?
No.
So if such conditions are there, the developer will end up paying the rental also. And if the allotee approaches RERA, the allotee will end up receiving the interest also under Section 18. So the developer, thinking that they are smart, they built up such sort of clauses, deviations into the agreement. Doesn't help. You cannot go against the law of the land, basically. That will reign supreme. That will override the terms and conditions of the agreement.
Now, here I just
Yes. You
Yes.
can. Yes, you can go.
You can, over and above rental, you can claim for interest. in the addition to the rental. Don't feel guilty of not enforcing the rental. You accept. Where the developer makes payments to the allottees.
Here, the question of deviation, I just wanted to ask you guys also that suppose on day one itself, you are now going to buy a property, and on the day one itself, you can clear cut see the agreement which has been shared with you and the draft agreement uploaded on the portal. So there is a simple deviation with respect to, I would say, one clauses of defect liability period. Defect liability period starts from the date of the possession, 5 years. In that, if you come across both and in an agreement you have compared, and that they have written that subject to allottees not making any changes into the flat. This one liner they have, if they have included in that particular clause. With the clause is non-negotiable, this line has been added in that, no, subject to not making changes. अरे soft possession लेते हो तो आप changes तो वहां पे wall का interior तो करोगे ही ना. So that means you are aware on the day one itself that this clause has been deviated, but you are keen, you want that flat only, the rate is good, what you will do? Anyone can answer? As an allottee, what decision you will take with respect? You are aware that this clause has been deviated. So you don't have answer, right? I would say that you will definitely sign that agreement. So that deviation is also, it is acceptable at the day one, but it becomes an issue when later on the project gets stalled. Because it is a big corporate, there is a project of 6 buildings, 100% there will be a delay. Everything you know from the day one, still you will invest. We have seen that. No matter you get due diligence from the top lawyer, anything done, you will know from the day one that this project will get delay, no matter what date has been mentioned in the RERA, still people buy. So that's where the point is. This whole deviation report doesn't serve the purpose until and unless you take a firm stand. Because at the day one itself, you won't fight with that developer. You won't go to RERA and complain, I'm an agreement, he has included this clause. So that has the agreement itself given on the portal shows that he has deviated. That means he has an intention. If you will go on defect liability period, he will see is in that contract, I have got this clause signed. Certainly subject to internal changes, he will prove that you have taken the flat for purpose of internal changes and you have appointed an architect and this has been done by you. So leakage is not in my jurisdiction. That is the reason that deviation also plays different role. It is acceptable to us at the beginning, but later on the same thing becomes a problem. Whereas we are aware at the day one itself that it is a problem. That's what the point is. RERA has approved this deviation. Correct. But RERA has always said that even if your project is registered, that doesn't mean that we have certified that project to be true in all aspects, that you have to verify. RERA is the authority only to display those agreements on the portal. That doesn't mean that if later on the developer has changed certain clause in the agreement and he has got signed from then they will be responsible. They have just plain a statement has been passed, any clause in deviation will be a void ab initio. But to prove that void ab initio, you have to go take up the ladder till High Court.
Yeah, so we'll move to the next question. So this next question, I think so everyone would be interested in this question because हर एक का कोई ना कोई client तो रहेगा जिसका registration cancel हो गया है, उसका project stall हो गया है. So my question to Aditya, that there are so many projects started pre-RERA period. They took the registration as ongoing, but subsequently either the projects were stalled or बीच में COVID भी आ गया. So COVID के वजह से many projects stalled, and many people didn't do their compliances initially. Their registrations were cancelled. So can you please throw some light on these issues, the cancelled projects, stalled projects? What is the thought process of the RERA authorities on this? Can you please, and as a consultant, what should we guide to our clients, those who are developers and their project has been stalled or their RERA registration has been cancelled? So can you please throw some light on this?
Yeah. Now this is a major issue currently. There are many projects you might have seen that all those projects either there is non-compliance due to which there is freeze of bank account. Now this regulatory RERA is doing all sort of things for freezing the bank accounts, for blocking the registrations, further registrations till they have complied. And there are approx 7,500 projects currently lapsed. So it is more of a regulatory aspect. Ultimately, see what is happening in that project needs to be properly scrutinized. Because there are 51,000 projects registered. If you will see, around 25 to 35,000 projects might be active, in this around 10,000, 7,500 to 10,000 will be your lapse count. So in every lapse project, there is one chartered accountant who might have given at the time of registration. So what is he doing? उसने certificate दिया तभी register हुआ. तो why is it not asking that promoter कि बाबा आपके project का क्या हुआ? आप बाद में मेरे पास आए नहीं. What is the current state of the project? Because whenever that project will be taken up for proper scrutiny, if suppose there is section 8 or a designated panel, there will be only one chartered accountant which has been listed on that project. So definitely the authority will be first questioning the chartered accountant whose certificate is on the portal. They will say, that is the reason apna email ID, mobile number lete. So in that case, why can't we be proactive and see to it that what is the stage and why is it not complying or getting the project registered, active? So that is the foremost role of a chartered accountant. If we have certain number of projects, and in that, if we come to know that certain number of projects are lapsed, so we have to check the health of the project. Why is it not getting completed due to funds, or at least make him apply for the extension? Because proactiveness to be shown, otherwise the project will get stalled, completely stalled. And currently, RERA is also issuing such orders that the QPR is not submitted, they are blocking. Now you will see that 4,000 projects were, they had sent a notice for blocking of the projects bank account. And later on, they suo moto released those bank accounts also, stating that in the favor of the allottees. Then prima facie, why did you did it basically? So you need to check what is happening in that project. A panel needs to be established, and what is happening in that project, that has to be scrutinized first, because 7,500 projects, there is nowhere about what is happening exactly. Some promoters are least bothered. No, promoters are of the view that if I will not sell out in the outside market and I will get the OC, though I don't need to register under RERA. What do you think? Whether I don't need to register under RERA? If my intention is not to sell, I'm getting an OC, I will do the construction by myself, I will get the OC, and then I will start selling. So post OC, I will start selling. So whether I need to register under RERA or not? Yes, anyone? Yes. But most of the promoters, if you will see, they will answer this query as no. I don't have to register if I'm not selling this project. But RERA was also of this view. RERA was also of this view. In a circular, they came up with this thing that if you are not advertising, your intention is not to advertise the project, you don't need to register under RERA. You can get the OC and you can then start selling. But conveniently, they have now deleted this circular, and there is an order which it is silent on this aspect, because it is not there in the act itself that only there are two exemptions, that is 500 square meter and 8 units. और वो 1 May 2017 का ओसी का वो तो बाद चला गया, अभी वो अभी है भी नहीं, ongoing project का concept. But this is where we need to be cautious that everything, every aspect will get covered under RERA, and that is the reason MARERA never gives an exemption certificate, which Rajasthan RERA gives in RERA. But MARERA never gives an exemption certificate. They will not bluntly say that. Till today, industrial, they have not said publicly that it is not applicable to industrial units. Whereas a tribunal gave a judgment that it has been clearly stated that MARERA had to advertise that it is not applicable to industrial units. So these are various aspects which we have seen that the labs project also is because of these reasons. Prima facie, to avoid labs projects, to getting the projects labs, the promoter needs, the MARERA authority needs to verify the means of finance, which we mention in the Form 3. That is the best possible source where a developer can be restricted from developing the project further if he doesn't have any funds. It is all, everything is going on the basis of assumptions that there will be sales, continuous sales in the project, and the project will be successful, which is not the case in today's scenario. So in case of SRA projects, you might have seen that 20% bank guarantee is obtained for the SRA construction cost. So why not possible in this sale component? Why is it only for tenants 20% construction cost needs to be ensured from the promoter and not for others? We are paying here a big amount. So in that case, that is the best possible measure to avoid the lapse project, I would say, if the means of finance is properly enforced at the time of the registration itself.
And I would just like to add one more thing. In a lapsed, when a project lapses, should we as a chartered accountants be concerned? We as chartered accountants come in various roles. One, we are statutory auditors. We certify Form 3, Form 5, etc. certification for even release of the payments from the bank. Should we be overly concerned? Should we not be concerned? How should we react? Okay, I'll rephrase it. Should we as a statutory auditor be concerned? Or it's okay, it's a business exigency, and should we ignore? What is the repercussion? What is the implication? Okay, during the year it happens. At the end of the year, we close the accounts. What is the disclosure requirement? Should we disclose? Should we not disclose? If we disclose, what should we disclose? Once a project lapses means the project has been delayed. The developer is liable immediately for penal consequences under MARERA. A lot of litigations come into play. Of course, contingent liabilities we'll have to quantify, we'll have to disclose it. Once a project gets delayed, automatically the disclosure under contingent liability comes into play. If a complaint is lodged, then the disclosure for litigation comes into play, legal disputes. Then if a complaint is awarded in favor of an allotee, do we quantify the amount of compensation, interest, and do we disclose it in the notes? Once we think about the disclosure aspect, then we will be extremely concerned when a project gets delayed in all aspects. And believe me, the disclosure requirements will be onerous. When we audit the books of a real estate company, though it may be small, private, limited, or whatever, the financials are looked upon by various authorities, the RERA, the MCA, the allottees as well. They look upon us to see whether the developer is in good state or not. Proper disclosures are not made. If the allottee looks at the financials and makes a decision to invest based upon the audited financials, then we are responsible. Lots of things come into play. So just food for thought. I won't delve deep into this topic. So food for thought. Can carry on.
Yeah. So next question is to Karthik sir. So during this COVID pandemic, there were two circulars which were issued by RERA. First circular was on 2nd of April 2020 and the second was on 18th of May. There was some relevance of that circular. But as seen, many developers are taking the benefit of those circulars and delaying the compensation or maybe reducing the compensation based on these circulars. So can you, sir, please guide us whether these circulars were for the benefit of the developers to avoid the compensation or it was for the project completion related issues?
Very good. Now, a project when it lapses has got serious consequences for the developer. The developer immediately will be liable for various penalties under 61, 62, 63, 64 of the RERA Act. And the penalties are high. It can extend up to 5% of the total project cost. Minimum, if once RERA authority starts levying the penalty on the developer, it doesn't start in thousands, it starts in lakhs. And it has got the potential to go up to 5% of the project cost. So COVID was a pandemic. This was considered as some sort of a act by the RERA authority. And to protect the real estate industry and not to unfairly burden the developers, it extended the registration timelines, completion timelines. In 2020, it extended by 6 months under Circular 13 and 14. And in 2021, due to the Delta wave, it extended by another 6 months. It stated that any project which had to get completed during that period will be extended by another 6 months in 2020 and another 6 months in 2021. So that all the developers got a 1-year extension of that. But it also had a mischief clause. It said there will be a moratorium on the payment of interest also. We have to carefully analyze the word moratorium. Moratorium means it's a deferment. It is not a waiver. But how the authorities have interpreted it, they interpreted it as a waiver. They wanted to give more benefit to the developers. It's an unfortunate scenario, but that's how it was interpreted. And the benefit of the waiver was granted on an ad hoc basis, arbitrary basis, without seeing the facts of the case across all the complaints at the authority level. They didn't give it blanket, but they said the developer will be able to get the benefit, enjoy the benefit of the moratorium, COVID moratorium circulars. And when it went out to execution, the adjudicating officers also, they straight away reduced 1 year of interest. Did the RBI provide us relief from EMI interest? No. It also gave a 3 months moratorium. It deferred the entire EMI. And the interest which was to be paid by the home buyers were in fact added up as a principal, and it was collected at the end of the tenure. The tenure itself was extended. So nobody gave any waiver. This case went to tribunal in Malti Siroya case. The tribunal rightly interpreted these circulars as mere COVID extension, registration extension circulars. This cannot have the effect of reducing the quantum of interest outflow under section 18. And the developer has to make good the payment for even the COVID period also. This was categorically held in this judgment. All the other judgments were also cited and quoted, like Nilkamal judgment, Newtek judgment, etc. Enforcing the rights of the allottees, stating that they have unconditional and absolute right. When they have unconditional and absolute right, how can a COVID extension, registration extension circular that were primarily meant to reduce the penal consequences due to COVID, due to lapse of project for the developer, act the further waiver of interest circular also? Both are different. So section 18 grants an unconditional and absolute right. The allottees should be paid full. But still, the authority is implementing, okay, if the date of possession falls before COVID, they grant the entire interest. If the date of possession is falling during that period, for that period, they reduce the interest. Still, the authority are following the same principle despite this tribunal judgment. So once we go to the tribunal, we get full relief. So that is the sum and substance of this Malti Siroya Kumbat case law. Kumbat versus Krishna Developers circular case law. It's a recent RERA appellate tribunal judgment. So this has reaffirmed the unconditional and absolute right of the allottee to receive the interest under section 18. So COVID extension, registration extension circulars will play no part in reducing the quantum of interest which is payable by the developer upon default. Again, why the primary question of interest has come? Because they have defaulted. Again, Kusheshwar Singh judgment comes into play. Can he benefit out of his own wrong? No. Why you are providing relief? Who is filing the complaint? The allottee is filing the complaint. How is the developer entitled to relief in a complaint which is filed by the allottee? Who is aggrieved here? The allottee is aggrieved, not the developer. So why, if any relief is granted to the developer in a complaint filed by the allottee, it doesn't make any sense. That's what.
Yeah, so we'll move to the next question. Next question is to Aditya. So Aditya, there are many developers who act as a black sheep. They tend to do various things which are not correct and which are illegal. So to be saved from RERA authorities, many developers, for their stalled project or to just show that they have completed the project, they have uploaded the occupation certificate or the completion certificate which are forged, and subsequently it had come to the notice of RERA authorities that There are many developers who have done this in the past. So what cognizance has the RERA authority taken now for such commencement certificate, maybe occupation certificate, which are the statutory documents issued by the competent authorities? So whether do they check the authenticity of these documents, or it is just नहीं है, चलो upload कर दिया है तो हम registration दे देते हैं कि every quarterly में आ गया है, हम उसका ठीक है next step पे. This is one part from the Maharera's perspective. And since for the registration of the project or at the time of completion of the project, so professionals like us also give certificates. So what cognizance we as a professional have to take in such scenarios?
Yeah. Now, this is a crucial issue. I would like everyone to hear this. Especially we are issuing Form 3 and Form 5. So I have seen, first of all, Form 3 has been issued for a project where the Form 3 consists of units up to 28th floor, for example. But in actual, the sanction plan is till 15th floor. So we are issuing something, and developer has sold beyond 15th floor also. And we have included that as a sales. No matter, we have to include the figures to the perfect. We have to note whatever is correct, but that has to be clearly mentioned in the observation that the sanction plan is till 15th floor and developer has sold till 28th floor. This is the stringent observation. This is basically illegal. This is not allowed. They sell on the basis of concession plans, fire plan, they sell, and they're even registered. I don't know how it gets registered also, but this is a crucial aspect. This is very much illegal. That should not happen. And in such Form 3, we have to be cautious while issuing. We always need to check with respect to, there are 2-3 parameters to be checked. First of all, at the time when the project, the registered for the promoter comes to you for the purpose of registration, obtain 2 crucial documents, that is the sanction plan and the commencement certificate. Now, you will say that whether we need to verify it. Yes. There were 65 projects registered in Kalyan Dombili jurisdiction. Right from the OC, CC, everything was forged. Everything was forged. Even the architect was not into existence. Developer को कोई ये नहीं है लेटरहेड पे बनाने का, सिर्फ अपने को यूडीन है, बाकी किसी को यूडीन वगैरह कुछ चाहिए नहीं. तो जो भी जाएगा अपन ही हम लोग, it will be crucial for us only to take certain steps. So it is very easy to verify. It is very easy to verify CC. See, if it is a BMC project, Maharera website is linked. Correct. So जो भी latest plans है, उसका आपको plan number डाल दोगे, तो आपको तुरंत उसका information मिल जाएगा. Even BMC, there is a citizen search website is available where you can verify all the documents free of cost. And for other municipal corporations, we have one website called as Building Plan Management System. That is a latest website we have, Building Plan Management, BPMS. On that, all the authorities, all the municipal corporations, see, there are hardly 10 to 12 authorities, they might have not mentioned there, but all the latest plans, all the plans which are now getting signed, those are digital. You will see the digital signature plans. Those plans you will get definitely on that portal. And if it is not there, then it raises concern. If it is a blue color plan, blueprint plan, that means it is an old plan. So either in that case also, if you want to verify, go to the architect. जो architect है उससे एक बार मिल के आओ, भाई तूने दिया है ना ये बराबर है. Are you the valid architect? This has been approved by you. That confirmation is also enough. But all the latest plans you will get on the BPMS site. Now, in a recent PIL filed by the architect who bought this all fraud in the Kalandubiri jurisdiction, the High Court strictly gave a uh, instruction to all the corporations that they should link their website with the RERA. That is a simple solution. Within the 3 months deadline was given. When I read that PIL, the 3 months deadline was also given in that order. But till now, that is not happened. You know the reasons for. So I don't have to tell those reasons. But we need to be cautious. CC verification needs to be done now. Likewise, OC verification also needs to be done at the completion of the project. An email has to be sent from the RERA, from the concerned municipal corporation. Those websites are not linked, so they have to share this. And always few figures, that is the sanctioned FSI, your proposed FSI, and your Form 3 area. This should always tally. This should always match with the plans. There are still today, there are many developers who will bring OC, but their one flat OC is pending. Single flat number OC is pending. That also needs to be, till that time also project is not completed. Till the time he gets that OC for a particular flat number. So there are two figures, sanctioned FSI and the proposed FSI. Concentrate on sanction FSI. Sanction FSI जितना है उतना उसका OC आ गया, बात खत्म. फिर वो प्रपोज बनाए ना बनाए, that is a different story. No one will ask if he is not constructed the proposed thing. But if sanction, he is not having the full OC, not part OC. Full OC is the OC which is recognized as a completion under, even in case of GST and even in case of our RERA. If you will see now, GST department has started sending notices for fungible FSI purchase, transfer of development, even for self-redevelopment projects, they are sending notices. And prominently two forms they are asking is Form 3 and Form 5. So Form 3 and Form 5 are the most crucial, I would say, most crucial documents, because we have their utmost responsibility which cannot be skipped, that is our UD. So easily we are accountable. Form 1, Form 2 तो आपको पता है कि क्या चल रहा है. वो इंजीनियर कभी तो इंजीनियर भी होता है या डिप्लोमा होल्डर होता है, उसको मान. एंड Form 1 डेवलपर अगर आर्किटेक्ट है तो वो खुद को ही फॉर्म दे देता है Form 1, and the architect also for this project. So that is a different story. But when the money, main thing is money which flows into the sector, that is controlled by us. So that is Form 3 and Form 5. So these forms will always be crucial document for income tax, GST and RERA. And it has to be, especially the March 31st Form 3. That is the most crucial document wherein all the departments can control and can ask for verification, can ask for details. So just don't give Form 3 or Form 5 without verification. We need, बहुत जन सीए ने मुझे पता है कि ये सैंक्शन प्लान देखना मेरा काम नहीं. It is our role. We are giving him the limit. और इससे बड़ा रोल क्या चाहिए? हम लिमिट दे रहे हैं, हम लोग सीसी फैसिलिटी दे रहे हैं उसको. तो हमने बोला 1 करोड़ विड्रॉ कर सकता है तो वो 1 करोड़ विड्रॉ कर सकता है, नहीं तो बैंक उसको विड्रॉ नहीं करने देगी. तो देन अवर रिस्पॉन्सिबिलिटी इज मैनीफोल्ड. आर्किटेक्ट ने गलती किया, वो डिफेक्ट लायबिलिटी पीरियड, उसके लिए वो लिटिगेशन में चला जाएगा, वो चलते रहेगा. बट फर्स्ट वन डिसिप्लिनरी एक्शन विल बी टेकन अगेंस्ट अस बिकॉज we have wrongly issued and we have allowed him to sell which is not allowed itself at the prima facie. So these verification points are there. You need to just use that BPMS website. You will get all the documents pertaining to the project on that BPMS website. So there are various points. I don't know whether you have attended my Form 3 and Form 5 session, but I generally cover. So there are cross-check points there. Form 3, we have basic tables of table E, your bank account. Here also we have your bank account, which gives the cumulative figure. So these 2 pointers, deviation. Other forms. Form 5 auditor is the earlier what we used to happen before 2021. Form 3 was supposed to talk about only cost. Major aspect, cost and the receivables. Later on, they increased the responsibility of Form 3 to deposit, utilization, and withdrawal. Now, these 3 aspects are with the Form 5 also. So there is a double check. Now, what differentiates between two is he gives every quarter, he gives once in a year. And he can comment on the irregularities observed in the Form 3. So what can be irregularities? That this is what these are the irregularities that Form 3 has allowed an inventory. He has reported an inventory, but no comment has been given, where the inventory itself is sold after the it is beyond the sanction plan. It is not within the sanction plan. So these are the various parameters, even in Form 2. Yes, he has to verify. See, first he has to verify what has been deposited is a lawful deposit. Then he has to verify that what is the withdrawal is within the limit of Form 3. And the third aspect is what has been withdrawn is utilized for the project. So right from the deposit word comes lawful deposit means, first of all, Section 13 restricts a developer to not deposit more than 70% in a separate bank account. So separate deposit pay restriction is 70-30. He cannot deposit less than that. Then to deposit 70% also, he need to first enter into agreement after receiving a 10% amount. So there is one restriction. So that has to be verified. Then in agreement, we have a payment schedule. And there is a payment schedule on completion of 40%, suppose plinth on completion of 40%, and developer has gone beyond that, he has not completed, but he has asked for more money. So whether he has given an early discount to the allottee. So these are the deposit, whether that deposit is a lawful deposit, it is a shortfall deposit or an excess deposit. People often consider deposit as wrong in Form 5. When they consider as excess deposit, if GST and income tax has been deposited, so not income tax, GST and pass-through charges has been deposited, they consider it as excess deposit. No. Are we supposed to answer that? No. Excess deposit is when it is told by law that it is 70% and has he deposited 80% pertaining to agreement value, not beyond that. Or shortfall only pertaining to agreement value. So there is a general misconception that other deposits are excess deposit. That means we are giving a wrong picture. We are saying that promoter is depositing excess, but that excess is not liable itself to be collected in that account. So shortfall or excess is pertaining to that agreement value itself. So these are various problems, and even in Form 2 we can comment. Now, Form 2, there can be a differentiation between Form 3 and Form 2. Cost. Now, most of the Form 2's people, they don't understand and they take Form 3 as a base figure. Correct? 90% cases. But that is challenge. Now, there has to be difference. Why? Generally contractor payments never, they don't bill. They don't issue invoice. There is a running account flowing because these guys don't want to pay GST on time. But the service has been completed. The milestone has been achieved. I have raised a demand notice to buyer. So there has to be a difference between Form 3 and Form 2 pertaining to cost. Because one is showing advance in the books pertaining to construction. Service has completed, but I might have not included it in Form 3 because the invoice is not there in PL. So this is not happening for InGL. So these are all different things. Even slow moving progress, RERA sends a notice on comparing Form 1, 2 and 3 pertaining to slow moving progress. So that is the reason we also as a Form 5 needs to comment on all these aspects. Whatever, if we are coming to know that the percentage completion is not in line with the architect certificate, then there is a, we are saying here that 99% cost has been incurred, and the architect is saying that 50% work has been done. There can be difference because estimated cost might have not been revised. That is a simple solution for that. This needs to be verified. Means he has obtained certain permissions and for that he has spent money from a different account. They will have 3 accounts, 100, 70, 30. And if there is a revenue sharing, then one more extra account, that is a master account.
Yeah.
There is no restriction. See, these accounts won't be allowed to be operated till the time we get RERA registration, 100, 70, 30. So all the prior money we have, if we have invoice, because incurred amount has been defined in RERA. So incurred amount has been defined in regulation. It has been clearly stated that you have to, the liability has to accrue. The liability has to accrue and you have assumed the liability against the creditor. That is one part. Second, you might have received the product or service on payment of cash. That is the incurred definition. So if I have incurred certain amount, I have paid, or I have invoice or premium bills, so I can include that cost as of suppose 4 crores incurred prior to the registration. Once we open the 170/30 account, we are allowed to withdraw till 4 crores as per the limit in the Form 3 earlier.
So previous account which he had earlier, that should be disclosed
in the accounts, not in RERA, not in Form 3. Yes, it will be disclosed in means of finance as own funds.
Yeah, but he will have 4 operative accounts.
He might close also. Once RERA has been, he has got the RERA registration, he can operate from 70%. All the spending can be from 70% pertaining to land and construction.
Okay. So in previous question, you asked us a question that if someone is selling his unit after completion, after issuing OC, you asked a question and I say that yes, he has to take a RERA registration. So again, I would like to clarify, he has to take or not?
He has to.
He has
100%. Because see what is happening, you know, even if he doesn't obtain the RERA registration, the agreement has to be as per RERA. Now, if I want to enforce the legal defect liability clause of 5 years after OC, where I will approach, where I will go. If the project register is not itself registered, I cannot file a complaint against the project. It will be considered as non-registered project.
Okay. One more question. Suppose there are 100.
Can we take this? This is one last question which we want to complete it. We'll take the questions after that.
Yeah, this is last question.
No, wait. I have one question to ask. We'll do it afterwards. So this is one important case which I think we should consider, means we should take up. So few questions back, Karthik sir had told that even society, means in case of a society redevelopment, society is also a promoter, correct? So here I have a question, sir. So अगर society भी promoter है, and society redevelopment mein he has some grievance or he has some issues with the developer, so can the society go to a RERA authority and complain कि बाबा ये हम लोग को ये ठीक से नहीं करके दिया है या ये ठीक से नहीं कर रहा है? So whether a promoter can go against a promoter in RERA?
Good question. It's a very, very recent judgment of May 2025 in case of Safalya Cooperative Housing Society versus Tirupati Developers, wherein The redevelopment agreement, everything happened way back in 2005. And the possession and everything was given by 2018. So post RERA, so the developer had to register himself with RERA. In all cases of redevelopment, one aspect is flats will go to the existing old tenants as an alternate accommodation. Second aspect is the developer, of course, will sell it to the new allottees. So the new allottees were also absorbed in the society because his existing society is already there. So the new allottees are also absorbed in the existing society. The society becomes an association of allottee. If the society becomes an association of allottee with the absorption of the new allottees, it also gains the character of an allottee, association of allottee. In this case, it approached. Usually what happens when the project is delayed to such an extent, the developer gives the possession, but many times doesn't give the OC. If the OC is there, BCC, building completion certificate, is not there. Haphazard manner, the parking is made. There are leaks, lift, proper lift maintenance area, everything, lot of issues were there. So when a society approaches RERA for even one aspect of OC, it will not approach the RERA for one aspect. It will open the Pandora's box. It will approach for everything. All the deviations which the developer has made, or all the violations which he has made, collecting non-payment of property tax, non-payment of lease rent, or excess collection which is not paid, collecting the maintenance before the OC, before handing over of possession, etc., everything. And the society went approached the RERA. The RERA recognized the society as an allottee and instructed, gave direction, ruling that whatever is pending has to be completed immediately within 30 days, and plus it gave liberty to the society to approach the adjudicating officer for further additional compensation as well. So this is a landmark judgment which is given by the existing current chairperson in case of Safalya versus Tirupati developers. So the society also, post absorption, it received the possession, but there were so many issues of parking, leakages, etc., and non-issuance of building completion certificate also, non-payment of property taxes, municipal taxes, lease rent, etc. It approached RERA. RERA recognized and gave liberty to approach the adjudicating officer for compensation, as well as bound the developer to complete all the requirements as mandated under the RERA law. So this is one of the fantastic things which I wanted to just point out and bring to all of your notice.
Yeah. So the time for the session has been, we have exceeded the time, but we'll take just 2 questions. Open house. So the case studies and everything is done. We'll only take 2 questions from the participants and then we'll close it. So yes, ma'am.
If the society goes for self-redevelopment, then it doesn't appoint a developer. Actually, that is the best and the most recommended and the optimum way of redevelopment of things, because the old tenants will receive the maximum area, maximum benefit out of that. There are 2 aspects in that. If you are gonna sell, I think it will have to register, basically. It will have to register. Because you will be selling There will be saleable component also, which you will be selling it to the outside public. And if you intend to collect the money, you will have to register on that. No. Here you are the promoter, straight. You are doing it for yourself. You will be classified as straight direct promoter. You will not be getting into the shoes of an allotee.
Only for the area which has been purchased, additional area, for that area you become an allotee, the individual society members.
Yeah. Sir, you can ask your question.
escrow में, because project का OC आना चाहिए. That means it is not completed. After that, if it is a new project after 1st July 2024, you need to follow the procedure in the bank operation order that first you have to upload the OC. You get an email from the authority that this OC has been accepted and you can close the account. So it is the OC for the project. So even if one shop or one flat OC is pending, you cannot close the bank.
So we'll close the session for this. Now I request Akanksha to take it forward.
Hello. So thank you, everyone, for the session. My heartfelt thanks to all the participants for your active participation, for the speakers, for enriching our professional knowledge, to the organizers for all technical assistance. I hope to meet you all in the upcoming knowledge sharing forums. Have a great evening, everyone. Thank you. Thank you.
Thank you, everybody.